Employers could face up to 10 years in jail or a 10 million rand fine if they distribute personal information without consent. The Protection of Personal Information Act came into effect today. Well, there you have it. You can have a large complaint against your boss for non-compliance on the conditions of a POPIA. Now, for more on this, we're joined by Dario Milo, who is media law attorney at Webber Wentzel. A very good evening to you, Dario, and thank you so much for your time. So, the Protection of Personal Information Act, of course, came into effect today. What exactly does it mean?
Well, it's been a long time coming, but it's finally in force. What it means is that citizens and what the Act calls data subjects now have enhanced protection for their privacy rights. And whenever there's an organization, whether it's a public body or a private body, a business, from a corner coffee shop through to a multinational, and that business is processing your personal information, they have to comply with POPI. So it really applies to businesses across the board, and the Act contains a number of conditions. There are 8 conditions altogether that have to be complied with. But the bottom line is, and the rationale is, to ensure that those who process our personal information do it seriously, do it carefully, do it in accordance with the law, and they take our privacy rights seriously.
Dario, can you be forced to be in a work WhatsApp group? Because obviously a lot of companies are making sure that this is somewhat compulsory for the dissemination of information. So is this something that you can also be forced to be involved in?
Well, if it is a WhatsApp group for business purposes, unlike for purely personal purposes, which is not covered by POPI, then whoever's the responsible party in relation to that WhatsApp group, which will probably be the administrator appointed by the company, would have to ensure that there is compliance with POPI. And one of the things to do to comply with POPI, generally speaking, of course there are lots of exceptions, but generally speaking, consent is king. If you get consent from the data subject, so if that's an employee, if it's a customer, if it's a supplier, and that consent is informed consent and is communicated to the responsible party, then you can process their information. And that's why we've seen lots of these WhatsApp messages go around asking if you consent. I think it's a bit of overkill because, for instance, a family group, to give an obvious example, is not required to comply with POPIA because that's purely personal activity, not regulated by POPIA at all. But businesses are required, and that's one aspect in which a business is, for instance, communicating with their employees, and they'd have to comply with POPIA.
So now you're mentioning that groups between friends, complexes, family don't have to get your permission to include you in a group.
Yes, but of course, bear in mind that that's from a POPIA perspective, but there's always the technological means of simply leaving the group. So if you don't want to be part of a WhatsApp group, you simply leave that group, and indeed you can even block a particular number. So that's not a POPI issue at all. It's simply a technological response to not wanting to be part of a group.
And the matter of companies that spam us with emails, SMSs, phone calls, can we now, of course, in some way, to a certain extent, threaten them with legal action, ask them to no longer spam us the way they do?
Well, absolutely. I mean, one of the key differences, the innovations in the POPI Act, is it empowers the data subject. Before, there was very vanilla protection, as I call it, for privacy rights. And one aspect of your privacy right fundamentally is the right to be left alone. So the right to be free of spamming, free of direct marketing, unsolicited marketing. So there are exceptions if the person gives consent. If I give consent to a company to send me marketing information, they can do so. If I'm an existing customer of a company, they're entitled to send me communications, but I'm always able to opt out of that. But certainly the practice that was quite widespread of companies simply spamming you with unsolicited mails and phone calls, etc., that will come to an end as a result of POPI. And if you are aggrieved by it as a consumer, you have a very easy way to now get recourse against the company, and that is to complain to the regulator. We heard the regulator a moment ago as well on your program. They have very, very significant powers, which ultimately could result in hearings, fines, and referrals for prosecution. So there are lots of very, very, very sharp teeth in the POPI Act.
Of course, I know there are certain companies where they give you the option to unsubscribe in emails that they send you that you don't wish to be sent. SMSs that say you can stop or opt out. What then happens if you do not get given those options by these people that are sending you unsolicited messages and emails? How do I get myself removed from their database?
Well, the big stick will be to make a complaint to the information regulator, and I suspect the information regulator will face quite a deluge of complaints on the direct marketing side from those kinds of instances. The other big area to watch out for, and I do a lot of work in this area, is data breaches, right? Because up to today, if a data breach occurred at a company or at a public body, there was no legal obligation under POPI to notify the data subjects or to notify the information regulator. Of course, there might be other legislation that applies in certain areas, such as health information, etc., that could apply. But generally speaking, there was no duty. You could sweep it under the carpet. But there is now what I call a duty to blow the whistle on yourself. You know, you can no longer sweep under the carpet the fact that a data breach, a cyber attack has happened. You have to, within a reasonable period, subject to certain exceptions, you have to notify the data subject, you have to notify the information regulator, and you have to tell them what happened and what they can do to protect their information. Because, of course, we've seen the phenomenon of, whether it's through social engineering, cyber attacks, etc., information being exfiltrated from systems and then being used, sold on the dark web, and often resulting in identity fraud and theft. So quite serious consequences. Both the POPI Act in conjunction with the Cyber Crimes Act, which also now has been signed by the President, although that one's not yet fully enforced. Together, those are two formidable responses from our law to the phenomenon of data breaches and cyber attacks.
And just very quickly before I let you go, Dario, how severe must the transgression be for you to actually face the full penalty of either 10 years in jail or a 10 million rand fine?
Well, can I just say that the 10 years in jail is really for the egregious offences where, for instance, you have ignored, you haven't complied with an enforcement order of the information regulator. So that's where the regulator will go through a whole process, a hearing, says that you've got to do something. Let's say they say you've got to stop transferring information to a country that doesn't have equivalent protection to us, because that's another condition in POPI, and you refuse to obey that enforcement order. That's very much like not obeying a court order. We've seen a lot of that recently in the last few days. That will be a criminal offence, and then you could be prosecuted, and the ultimate fine or punishment for that is either a fine or potentially jail time. But that's for the extreme cases. More likely will be that if you infringe one of the conditions of POPIA, you will face administrative sanctions, and that would mean going through the hearing and ultimately the information regulator up to a maximum at the moment of 10 million rand imposing a fine. And of course, we've seen very, very severe breaches in recent years. Now the information regulator could act if breaches occur, data breaches occur from today. But I suspect a lot of the initial work around POPIA, and indeed, hopefully this has been happening already with companies in the last year when there's been this kind of waiting period, is that there needs to be training of employees, policies, procedures have to be beefed up and enhanced. You have to revisit your contracts that you've got with suppliers, with employees, with processors who are processing information on your behalf. And all of that has to be rendered compliant with POPIA. So it is quite an uphill battle to become POPIA compliant, but hopefully that's what many of the companies, our businesses and our public bodies have been doing in the last year.
Dario, thank you so much for your time on Newsnight this evening. That is Dario Milo, who of course is media law attorney at Webber Wentzel. Still to come.